Special meeting of the Oklahoma City Water Utilities Trust will be in order. The first item on the agenda is the approval of a storage contract transfer agreement between Oklahoma City Water Utilities Trust and the State of Oklahoma Water Resources Board.
Move approval.
Second. Marcia, can you give us a bit of an explanation of the terms?
Mr. Chairman, your general counsel, Trustee Couch, your general counsel will be giving us a summary of the terms of the contract.
Thank you.
Chairman and trustees, the transfer agreement would propose to transfer the rights of the State of Oklahoma through the Water Resources Board in the 1974 contract with the United States of America through the Corps of Engineers to collect and store water in Sardis Lake. Those rights would be transferred to the Oklahoma City Water Utilities Trust or its successor. The Oklahoma City Water Utilities Trust would agree to be responsible for future and existing unpaid obligations of the state under the 1974 contract. The payments include a possible $15 million payment, but that payment is timed to be after a water use permit is issued, if one is issued. The transfer agreement preserves the rights of the Sardis Lake Authority under its subcontract that currently exists, and preserves the rights of southeastern Oklahoma in the administrative set-aside of the 20,000 acre-feet of water storage in the Lake Sardis. The transfer agreement does provide that the Water Utilities Trust would be able to recoup its costs in providing storage to third parties by establishing fees based upon generally accepted accounting principles and AWWA standards. The Oklahoma Water Resources Board does not guarantee the issuance of a water use permit. This agreement is for water storage. The Oklahoma City Water Utilities Trust acknowledges that the city has pending an application before the Water Resources Board for water use in Lake Sardis or the Kiamichi Basin as a whole. The parties would agree to cooperate and coordinate on water quality issues, and the transfer of rights would be subject to subsequent approval by the U.S. Army Corps of Engineers.
Mr. Chairman, I have some questions. Mr. Keith, so there's a 1974 contract between the federal government and the state of Oklahoma for storage of construction like that and storage rights.
That's correct, sir.
And so what we are doing is purchasing a time of those storage rights from the state, their interest in that contract.
That is correct, sir.
And this is very similar. It's going to remain a Corps of Engineers facility.
That's correct.
Just like Lake Canyon.
That's correct.
Well, we have storage rights in Lake Canyon. It's a Corps of Engineers facility.
Correct, sir.
And just like it's happening at the Deep Creek Authority, where we have storage rights in the Deep Creek Authority, but it's a Bureau of Reclamation facility.
That's correct.
Okay. And what we are basically paying is what the obligation that they have to the federal government. We're making the state, taking them out of that obligation, and we're repaying them potentially $15 million to make them whole for previous payments that they have made.
That is correct.
And it's also my understanding that we're restricted from selling any of this water or out of state.
That's correct. We have an obligation that we were going to sell and use the water for Oklahomans.
We're not purchasing 100% of the water in this lake or the storage rights in this lake, are we?
We are purchasing the remaining storage rights in this lake. There has been a set-aside for southeast Oklahoma of 20,000 acre-feet per year.
Okay.
So those will remain untouched. We are not.
Right. We have to take subject to that condition.
That is correct.
Okay.
Any other questions? I guess we're ready to vote. We have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion is approved. The next item is item to authorize the general manager to obtain the approval of the contract between the trust and the Water Resources Board from the Corps of Engineers and from the U.S. District Court.
So moved.
Second.
Motion and a second to approve item 2A2. Comment?
Mr. General Counsel, can you describe this to us?
Yes, as one of the conditions of the original contract between the state and the Corps of Engineers in Article 10 was that the Corps of Engineers would have to approve any assignment or transfer of the storage rights. That's a process that would need to be gone through subsequently. Before the Corps of Engineers will look at the issue, the new storage rights holders also has to have a water use permit. And since that process has yet to be gone through, that cannot be done yet. In addition, there need to be some coordination between the city, the state, and the U.S. government through the Corps of Engineers to make sure that all the conditions of the state's 2009 court order have been complied with. So those processes we need to work through, but it is one step at a time subsequent to this approval.
Further questions? Is there the possibility that we can go through this process and issue bonds and spend this money and wind up with nothing?
I don't believe so. I believe that we are buying an interest in property. We have set up the agreement so that that interest in property can be secured. I believe that we would have that interest, and that should the state decide to try and sell to someone else or use it contrary to their contractual obligations, that we would have rights under the contract. So I believe we're paying for a valid consideration.
But if the Corps of Engineers doesn't approve of it, then the payment would not be made?
If the initial payment for July 1 would be made, if the Corps of Engineers does not approve the eventual transfer, then we would have to go back and talk to the state about how to become whole or to have them assist us in achieving the intent of the agreement. And in the agreement, there's a provision that says the state will support us in our application to the Corps of Engineers and will coordinate and help us with that issue. Our discussions with the Corps of Engineers is that it's a procedural matter for them. They have to make sure that all of the guarantees that were promised to them in the 1974 contract are being upheld, and so it's more of a procedural process for them.
Further questions? Hearing none, all those in favor say aye.
Aye.
Opposed? Item 2A2 is approved. Next item is item 2A3, which is a request authorization for the general manager and the municipal council to hire outside counsel to possibly institute legal proceedings that may arise as a result of this.
Move the item.
Second.
A motion and a second to approve item 2A3. Is there a question? Yes.
Mr. Chairman, that was put into the agenda at my request, although the city has not received, and nor has the trust received, to my knowledge, any commencement of any action. There has been several newspaper articles and several groups who believe that they do have a right to an action, and we need to be prepared to effectuate the contract as was intended. And because it involves potentially very obscure issues of both water law and potentially Native American law, we may need some additional outside help.
Questions? No, sir. Hearing none, all those in favor say aye.
Aye.
Opposed? Item 2A3 is approved. There is no further business on the regular agenda. Does he want to speak? Yes. Okay. Is there new business? Next item, item 4, there are comments from, we have a request from a citizen to speak. Are there comments from trustees or staff? Mr. Amont? Please give your name and your address for the record, please.
Certainly. Chairman, my name is Jason Palmett, and my work address is 1723 South Boston Avenue, Tulsa, Oklahoma, 74119. Thank you very much for permitting me the opportunity to address you, and it's good to see some faces I recognize on your board. I sent you a letter, each of you a letter, which I believe you should have received today. I did my best to get it to you as quickly as I could when I'd understood and saw the posting on the Internet on Friday. And I understand that effectively the decisions have been made. But I imagine that as this board still sits here today, you could consider or reconsider the actions that you have just discussed briefly, very briefly. And really, folks, the 2 points that I want to bring to your attention are, first, that I've reviewed the letter from the Army Corps of Engineers, as I'm sure you have as well, which was attached to my letter. And it appears very clear that the Army Corps of Engineers will not grant the approval that the Water Utility Trust is seeking. And at the same time, in Section 2.2, on page 5 of the draft agreement that is posted on the Internet, the Water Utilities Trust is agreeing to bear that risk. So effectively, you'll be spending millions of dollars at the risk that the Army Corps will not approve the contract. And it appears very clearly from their letter that they will not. So effectively, I think one of the questions, Chairman, that you'd asked is this a dry hole that you're sinking all this money into? And I'm a lawyer for Oklahomans for Responsible Water Policy and not for the city's utility trust. But we have members here in Oklahoma City who are both ratepayers and taxpayers who are concerned that they don't want to be burdened by the payment of money that may be unlawful or illegal. And as a result, we feel that you should reconsider the decision to enter into this contract while you're bearing entirely the risk that the Army Corps will not approve this contract that you seek to sign, specifically with the evidence that's before you, the Army Corps' letter stating that it will not. Secondly, I'm very troubled by the terms of the contract itself. I've reviewed earlier copies of the contract which were available on the Internet at various different times as you were considering this contract, but then didn't. There have been at least 2 prior versions of the contract that have been publicly available on your Internet at various different times. Those contracts are written differently than the current one, but all 3 of them essentially provide that the Utilities Trust is agreeing to pay $15 million in exchange for a water use permit from the water in Sardis Lake. There's no provision in Oklahoma law that permits any person or any utilities trust for paying for a permit, nor is there any provision in the law that permits the state to accept payment for a permit. Such a payment and such an arrangement and such transfer of money would be clearly illegal, unlawful, and would require, I believe, the citizens of the state and the ratepayers of Oklahoma City to seek the reimbursement of that money. And I don't want you, not here to threaten you, not here to tell you that how to do your jobs. You've all obviously made a conscious decision here. But what I am here to advise you is that we feel very strongly about this matter. We hope that you'll consider these significant risks and go forward with this thing in a way that we can all work together. And we believe very strongly, and I can say on behalf of Oklahomans for Responsible Water Policy, that this current plan, which is embodied in this contract, does not appear to be a way forward for all of Oklahoma. We hope that we can find a way to work together. Thank you.
Keith, you want to respond to that at all?
Mr. Chairman, with all due respect to Mr. Ormond, I believe that based upon his letter, he is relying on a statement in the memo, and the memo was put together to consolidate issues and maybe could be stated a little differently, and we'll work on that for the council memo. But I will note to you that there are 6 places in the contract where it clearly states that the provision, the application for a water use permit is separate and distinct from the storage right issue, that we acknowledge that there is a process and there's laws and procedures which dictate the application and the granting of water use permits, and that this is not an attempt to purchase a water use permit through this contract. It is a condition precedent to repaying the state the money that they have previously paid for the value of the lake during the time which it has and holds the water storage rights. Then with regard to whether or not the Corps of Engineers would grant approval, Corps of Engineers has a process, and we're comfortable with that process, and we believe that they will look at the issues objectively, and they are looking at whether or not we have a reasonable ability to pay, because their issue is to be repaid for the investment the U.S. government made on the lake when it was created. And we think we can comply with all those provisions. We are AAA rated. We are rated as well as the state is rated. We are one of the top-rated utilities in the country, and I believe they'll be quite pleased with the assurance that we can make all the commitments we are engaging in.
One thing that occurred to me about this was that, we've been in this process for a long time. I suspect it's been as long as 15 years or so we've been in some form of this process. As you know, as you and I experienced with McGee Creek, there were some things in that transfer agreement from the Bureau of Reclamation when we took that agreement that we spent 15 years or so after that cleaning up. Have we looked to make sure there aren't things like that in this agreement?
We don't see that there are any obstructions that would prevent this agreement from being effectuated in the way that it is intended. I'm not saying that working with the federal government does not have its red tape, delays, and challenges. And I believe that any time that you have the federal government funding a project for you, you're going to have requirements, and even requirements that can change on the fly, whether they be a RRA projects or any other federally involved projects. So will there always be smooth sailing? I can't guarantee you that. Do I think that we can effectuate the intent of the agreement? Yes, I do.
Thank you. Any other comments?
I just want to say that I have received the letter that came down. I've reviewed the letter, heard the comments today. I appreciate those comments as it's gone forth. And although they were brought forth earlier, but he made his presentation after the vote was taken, I have considered that and don't have any desire to reconsider the contract. I'm very comfortable going forward, and I just want to say that for the record that I am comfortable with the vote taken earlier.
Any other comments?
No, sir.
Hearing none, I believe there's no further business